basis. Just a value add to our services, wanting to keep you all updated on everything that's important to your business. Today we have Tom Berry, and he's an attorney with Jackson Lewis, and he will be talking with us just about the latest employment law updates, what you need to know with your business, upcoming changes to be aware of, and we'll kick off momentarily. Just a few housekeeping things before we get started. Everyone is muted, as you've probably already noticed, and in listen-only mode. Now that does not prevent you from asking questions. You can use the chat or the question box throughout the presentation today. I know Tom has some questions built in, so we're definitely happy to make this interactive using that chat or question feature. Our presentation today will last less than an hour, so you'll get some more time back in your day to hopefully catch back up this morning. But before we get started, I would like to, I was looking at the list today of people registering and who's going to be joining us today. And I thought I would be doing a disservice to all of us if I didn't talk just a couple seconds about just higher level. And I know we have a lot of great HR leadership on the call today in different operations. I was kind of looking at the list. We have a lot of people from Illinois and Missouri. And one of the great things that we've really seen this year on our side of our staffing business is an increase in direct hire opportunities. For years, we really specialized in temp to hire. A lot of people may look at us as a temporary employment service, which we're a lot more than that. But we have really a lot of great direct hire opportunities across many states, not just Illinois and Missouri, which a lot of people think that's where we're kind of based out of, and we are, but we work on positions remote in all different states. Our national recruiting team has a pretty large footprint with kind of what we're specializing in. So I wanted to take just a couple seconds here and talk about some opportunities that we have. So if you know someone, or maybe it's you on the call that's interested, you can reach me directly at hello@higherlevel.com. Feel free to drop your email in the chat. But we have some great opportunities that may be in some of your wheelhouses with payroll and benefits specialists in Bethalto, Illinois. We have a payroll benefits specialist. We are also looking internally at higher level with different opportunities. One that came across my desk yesterday was also an auditor and a tax preparer, and that is in the Cape Girardeau, Missouri area. We have a floating financial advisor in Edwardsville, executive assistant in St. Louis, and then multiple operations managers, warehouse type positions. I know we do have some operations people that's on our call today as well. So just a little kind of a blur before we get started about that too. That's one of our specialties. And so even if you're on the call today and not looking for a new role, but maybe you're looking to hire, we know what all goes into that. And so feel free again, hello@higherlevel, that's the best way that you can reach me. Feel free to reach out, drop your email in the chat. And all right, Tom, I'm going to kick it off for you.
Thank you, Erin, and appreciate the opportunity that Higher Level has afforded me to talk for the next 55 minutes or so. I've got a number of topics, and of course, we have to have the standard legal disclaimer that they always make us add. But nonetheless, I'm hopeful that the next hour or so will be constructive and productive for you. We're going to be talking about essentially 5 different topics, and then I'll pause between each topic for any specific questions that any of you may have. But first, I want to talk about the paid leave law that was passed by the state of Illinois earlier this year. It will not be effective until next year, but frankly, now's the time to start planning for it. I'm also going to talk about changes in essentially paid bereavement leave that the state of Illinois has also mandated starting this year. I'm going to switch then away from Illinois. The last 3 topics are going to be sort of federal law topics. And first of all, I want to talk about the recent initiative that the National Labor Relations Board has taken on to essentially try to attack any employer severance agreements or separation agreements that you may reach with departed employees. So I want to alert you to some developments there. And then finally, I'm going to talk about two new federal laws that were passed literally at the end of last year when most of us were planning for our New Year's festivities. There was a new law that was passed that provides greater enhancements and protections for female employees who need to express milk while they're working. So I'll talk about the new Pump Act, as it's been conveniently named by Congress. And then finally, I'm going to talk about the recent changes that are going to affect pregnancy employees, protections and rights for accommodations. This will certainly be more of an issue for the Missouri employers than the Illinois employers, because in large part this has already been covered by Illinois law, but nonetheless it's going to be a further expansion by the EEOC into our employment practices. So I first want to start off the Illinois Paid Leave for All Workers Act. And if any of you happen to be subscribers or received the Illinois Business Journal, there was an excellent article about a month or so ago summarizing this act, and I had provided some input to that article as well. But if this is new for you, you've got to understand that. Starting this year, starting in 2024, every employer is going to have at least a base minimum of paid time off that your employees are entitled to use. And so at a minimum, every employee will have to have the ability to take up to 40 hours off in the next year for any reason. Now, this bill was fast-tracked through the lame duck session of the Illinois legislature, so it literally was introduced on January 6th, which was a Thursday, and it was passed by both the House and Senate the following Tuesday on January 10th. So as you can see, there wasn't a whole lot of debate or frankly notice that went out to the business community when this bill was introduced and passed. It's now been signed by the governor, and again, it will be effective, starting next year on January 1. In terms of who's entitled to paid leave, it basically covers every employer of whatever size throughout the state of Illinois. The only couple exceptions were for students that are working at universities or community colleges, and FedEx driver, UPS drivers, and Amazon drivers. Other than that, if you have one employee or 1,000 employees, you're covered. For those of you who are Missouri employers, if you have employees that are working remotely and they live in Illinois, they're covered as well. And so you have to be mindful of that potential reach. It covers both full-time and part-time employees, although the part-time employee cannot accrue up to 40 hours, but they certainly can accrue up to what is their normal weekly schedule, whether 10 hours, 20 hours, 30 hours. They can accrue a pro rata share consistent with their work schedule. And starting January 1, the employees who are covered by this act will accrue 1 hour of paid leave for every week that they work during the next 12 months. Or whenever they're hired starting after next year. And when the employees take the paid leave, it has to be paid out at their base rate of pay. And so even for a salary person, you have to, correspondingly, make sure you pay that out the same rate. If you have tipped employees and you're an employer that takes advantage of the tip credit, you're gonna have to pay them based upon the state minimum wage for their paid leave. Interestingly enough, the employee has zero notice obligations or duties to you. All they have to do is tell you they need time off, and they don't have to explain why. And you cannot require them to explain why, and you can't require them to provide any documentation to corroborate that they were using the leave for the reason that they may or may not have told you about. Finally, you can't require the person to arrange for someone else to cover their shift when they take off. Now, there are some other exceptions. First of all, for those employers that may have employees up in Chicagoland area, there's already, Cook County and the city of Chicago has its own paid leave statute. So you'll have to abide by that statute in lieu of the Illinois. If other municipalities this year were to pass a paid leave bill, which is, again, not very likely, then that would, preempt. But otherwise, the Illinois Paid Leave Act is going to be, the floor going forward. For those of you who may have employees that are covered by a union contract, the terms of that, CBA are going to, govern rather than the statute. Although once the agreement, expires and is renewed after next year, you're going to have to include either, the paid leave benefits as part of the union contract, or a clear and express waiver that the employers are foregoing those rights, which again will be, a difficult challenge. For most of you, though, who don't have union contracts, but you do have your own likely, paid PTO policies, vacation policies, sick time policies, personal time policies, you're going to have to redecide, how am I going to integrate the paid leave benefits with my existing policies? And certainly going to need to update your policies throughout the year to make sure that they are ready to go come January 1, because there's some hidden traps here. If you just simply roll it all into one PTO bank, there's some hidden traps that you need to be aware of going forward that I'm going to talk about here in a couple of minutes. So first of all, again, the employees will, accrue, as the default provision, 1 hour paid leave for every week that they work. Now, the employer can essentially start the year off and front load everyone with the 40 hours of PTO time. And the advantage about doing that is that, if you front load the 40 hours on January 1st, it's essentially a use it or lose it benefit. So at the end of the year, if they have, some hours of the Illinois paid leave left, they will lose it. If you don't front load it and you require them to accrue on the 1 hour for every 40 rate, then anytime they have the end of the year will automatically roll over to next year. With the caveat there is that they still can't take more than 40 hours in 2025. So if they roll over 10 and some reason, and then get the accrued the whole 40 in 2025, they cannot take 50 hours that year. They would essentially roll over another 10 again. But again, if you don't front load it, then some employees can, over the years, really build up some big banks of accrued state paid leave time. So that's something you need to consider. You can require employees to take, this leave in at least, minimum increments of, 2 hours or more, but it can't be, sort of a guise for 15 minutes late, I'm going to, cover this for my paid leave benefits. What sort of notice obligations are you going to require? Most of your leave policies probably have a notice provision in there. Again, in a sort of a cruel twist of fate, the statute says that employers can, or employees are required to provide you at least 7 calendar days notice that they're going to use their state paid leave if their leave is foreseeable circumstances, if not foreseeable as soon as, practical. But again, going back to, they don't have to give you a reason. How are you ever going to know if the underlying reason was foreseeable or not? And so, hopefully, and again, 90% of most employers will do the right thing and will provide you advance notice if they can. But the 10%, and we all know who those folks are, they simply will probably call you up that morning saying, I'm taking today off for paid leave, see you tomorrow. And there's not a darn thing we can do about, that, because we cannot, establish that was foreseeable or not. So again, the statute does not apply to those employees who work in Cook County. And again, for the union contracts, the best practice is is to, try to comply with both of it if you can, but otherwise the existing terms will take precedent until the new agreement expires. But this is something you may see some requests from your union employees about. Finally, and again, this is where it gets tricky about how you integrate this is, and many of you may realize that under Illinois law, unused vacation time has to be paid out at the time the employee departs, whether voluntarily or involuntarily. If you have separate times for sick time and separate banks for personal time, those unused hours do not have to be paid out. If you, however, combine vacation, sick, personal, all into a single bank of PTO time, then all of the accrued hours have to be paid out at the time of separation. So going back to my thought about if you don't front load it, then they can roll over and roll over and roll over. And if you don't set up the state paid leave as a separate bank of time, you're gonna have to pay out all that accrued but unused state leave time at the time of separation. So again, that's something to think about. Do I want to incorporate it into my existing PTO policy, or make this a separate bucket of time that my employees have to use in the next year? Other challenges here is, every employer probably has certain busy days during the week or busy times during the year. And so I can certainly foresee a lot of retail employers having a lot of problems, Black Friday of 2024, when suddenly 3/4 of their staff say, I want to take my paid leave day that day. So we cannot cap how many employees use paid leave at the same time. You also can't have any blackout periods. They can use this time whenever they choose, for whatever reason they want to choose, with little or no notice to you, and there's not anything we can do to stem that abuse. And again, if you provide unlimited PTO policies, it's going to be a real headache in terms of how to integrate and administer. So again, if you already have, a full PTO policy and you don't have vacation, sick, or personal leave policies, you may want to consider front loading these paid leave hours, so at least those are use it or lose it at the end of each year, as opposed to growing and accruing and becoming the self-funded retirement annuity. Obviously, a combined single leave policy is certainly easier for your staff to administer. I fully get that, appreciate that. Having to separately administer FMLA policies, other leave policies, vacation, sick, personal times can be an administrative headache. But again, if you're going to maintain them all in a single bucket of paid time, you have to essentially make them all the time consistent with the Illinois requirements about no notice obligations or no documentation obligations until such time as they use their full paid leave bucket. And again, if you do combine it and you don't front load the paid leave, you could have a much larger, accrued liability for accrued but unused paid time that you have to at least not only carry on your books, but more importantly, pay out to the departed employee at the time of their final payout. Separate policies obviously means that you can keep your existing terms and conditions to your own already provided policies. And if you keep separate vacation from sick and personal, you can keep the paid leave separate as well. And the only thing you're going to pay out the time of departure is the unused vacation hours. The rest of the times are forfeitable. But obviously, doing all that, administering all that is going to ensure that you need to have staff that are vigilant on top of it and probably maintaining multiple spreadsheets so that we don't have, any confusion at the time of separation about how many hours from which bucket they have and which ones are properly paid out. And then lastly, if you've got both your employer provided time and the state paid leave as a separate bucket, they get to pick and choose when they want to rely upon their state leave bucket. So it may cover both vacation and state leave. They get to choose which bucket, they draw from. We can't mandate that they burn their first 40 hours from the state leave and then start using their vacation time or their personal time or the sick time. So yes, this was written and fast-tracked from a very employee perspective. Finally, be aware that the Illinois Department of Labor will be coming up with a new and improved, posting requirement and notice to employees. You need to make sure your record keeping is sufficient. The state will have the ability to come in and audit you for up to 3 years, starting next year. The Attorney General has the ability, if he wants to pursue violations if it gets referred by the Illinois Department of Labor, and there's additional penalties that the Attorney General can recover, and the employees can recover any number of damages if there's a dispute, with how this law was administered. So again, lots of tripwires here for employers to be mindful of starting next year. So at least want to pause there and at least open up for any initial questions, if any, before switching to the next topic. Or we can certainly, obviously get them at the end of the program as well, but at least want to pause for a moment.
All right, thanks, Tom. I'll keep an eye out for the next minute or so and see if we have any questions coming in.
Okay. So now let's talk about the, was there a question?
Yeah, here we go. So yeah, we have a question from Karen. She'd ask if you can elaborate on the reasonable minimum increments.
Well, you can require them to at least, use it at 2 hours at a time. But it's not intended to basically allow them to backfill tardies or being late. So if they're going to use paid leave, you can say that you have to at least use it, for 2 hours at a time, as opposed to I need to be off for the morning. Well, you're going to burn a whole day of paid leave. So you don't have to break it down to how many minutes during the 8-hour day, but you can, keep it to, if you're use paid leave, it has to be at least 2 hours a chunk. So if you take off, you're off for 3 hours, you're going to burn 4 hours and be paid for 4 hours of paid leave. But you can't require them to use a full day if they need, a less time during the day. So hopefully that's clears that question up.
All right, and we do have another one that came in too. So if we offer PTO, do they have to add to this policy?
You need to, well, if you're already offering greater than 40 hours during a week as far as your personal time, you don't have to add another 40 hours on top of that, but you are going to have to change all the notice requirements and documentation obligations so that you're otherwise being consistent with the fact that they can ask for this at least 40 hours, with no notice and no documentation. So you just have to alter whatever requirements you have, in your policy, such as, you must ask for this at least 10 days in advance. You just have to make sure that all those other provisions are streamlined to be consistent, at least for the first 40 hours. But essentially, if you're already providing, full-time employees accruing greater than 40 hours during the week, then you're going to be okay. The other thing is very few PTO policies, in my experience, cover part-time employees. So you need to make sure you amend your policy to now provide at least part-time employees the ability to accrue some paid time off benefits.
All right, Amber, I know you had asked a question about the part-time. Let me know if that didn't answer your question. And then Charles had asked, how does this affect temporary workers?
If they're on your payroll and they're, if they're truly on, they're not on your payroll, they're on the temp service payroll or the higher level otherwise, then that's their, requirement to administer with their employees. But if they're, on your payroll and they're, getting a paycheck from you, even if it's just a temporary period of time, they're going to have to be able to accrue those hours while they're still working for you. So temp employment arrangements can take a lot of different forms, but whoever the W-2 employer is for that individual will have to provide this benefit for that individual.
We have a few more coming in. So can the accrual process be different for part-time versus full-time?
It has to be pro rata with their work schedule. So if they ordinarily work 20 hours a week, then it's going to take them, 2 weeks to accrue an hour. So at the end of the year, they would have accrued, 20 hours of paid leave. So it's the same 1:40 ratio. So if someone's working 10 hours a week, it's going to take them 4 weeks to accrue 1 hour of paid leave. But we sometimes fall traps like, well, it's 1 hour for every week of employment. Now it's really 1 hour of 40 hours worked. And again, not 40 hours paid. So if they, in that week, if they took paid time or sick time from last year, they've only worked 32 hours in that week.
Gotcha. And then Laura, I'd like to take your question offline. It's pretty lengthy, Tom, so maybe we could connect afterwards and get Laura's question answered.
Sure.
Okay.
And again, I'll have some time at the end of the program, but I want to sort of switch over now to cover the changes for the essentially the paid bereavement leave that now exists in the state of Illinois for, again, 2023. And again, if you are in Missouri, but your employees work remotely and live in Illinois, these benefits would apply to them as well. So, you may remember several years ago that the state passed what was called then the Child Bereavement Act that provide for paid leave bereavement, in the, God forbid, tragic situation that an employee lost a child. This year, it's been expanded now to be, family bereavement leave. And so it's obviously expanded the scope of qualifying family members for paid funeral leave, bereavement leave, as well as expanding the circumstances, and we'll get into those in a moment, that also will trigger a bereavement leave besides just a death of a family member or child. Now, the good news here, if you're not an FMLA covered employer because you do not employ 50 or more employees in a 75-mile radius, the statute doesn't apply to you. But if you are an FMLA covered employer and you have FMLA eligible employees, meaning they've been with you at least a year and work at least 1,250 hours, then they also will be entitled to bereavement leave, which may or may not be a FMLA qualifying event depending on the circumstances. So again, as I mentioned, this on the left side, you have to be an FMLA covered employer, and these leave benefits are only available to those employees who are otherwise FMLA eligible. But the qualifying events now are beyond just the death of a child. It's now a broader group of family members. It's also going to cover, employee may, experience a miscarriage or have a stillbirth. It's also going to cover those employees who may be going through in vitro fertilization to try to, become pregnant. It can cover now someone who had an adoption arrangement fall through, or other, pregnancy or fertility, procedures that had a negative result. So again, it's got a much broader reach than we would typically think for a bereavement. The expanded family members that now have, again, bereavement leave include the employee's spouse or their domestic partner or their brothers and sisters or their parents or their step parents or their in-laws or their grandparents or their grandchildren. So again, if any of these folks, pass away, your employee is entitled to take up to, 10 days of bereavement leave for each, instance. Now, they can only right now use up to 3 different, deaths during the year, but they can take up to 10 days off if one of these family members, unfortunately passes away. Domestic partner is, again, defined broader than we would ordinarily think, and includes someone who may have been, a domestic partner through a civil union arrangement or otherwise, but also includes someone in a committed personal relationship with the employee. So, and it doesn't provide any standards for when someone, reaches that level of a relationship. I'm reminded of an old Seinfeld episode about whether or not, a date on the weekend was implied or you had to ask. But it does, again, for someone who has a long-term significant other that they're sharing the same household with, even though they may not be married, this person also would trigger a leave entitlement. Again, I would suspect in most instances that won't be a trouble to apply, but I think I could certainly see someone say, "Oh yeah, we've been dating, for 6 weeks, and I view it as a committed personal relationship." So be mindful that has some broader reach potentially. Again, the employee can take, no more than 6 weeks off, 10 days for each incident, up to 3 during the year. And this leave is unpaid, but certainly it might qualify under your other paid leave benefits or your PTO policies, or the state paid leave, depending on how many hours they have left. The Illinois Department of Labor is also going to be, coming up with some forms that you can utilize for employees that are requesting bereavement leave for the circumstances that may involve, a pregnancy or a medical procedure associated with that. You can't specify which one of the underlying medical reasons might have, resulted in the bereavement situation, but you can require at least the doctor to certify that the person is entitled to the time off based on either pregnancy, adoption, surrogacy, or other fertility procedure, consequences. So if someone's asking for this leave, make sure you go to the Illinois Department of Labor form and download their leave forms. Again, unlike the state paid leave statute, you can at least require them to document their request for bereavement leave in this instance. Questions about the expansion of the Illinois bereavement leave from children to family members and beyond?
Don't see anything right now, but I'll keep an eye out if something comes up.
Thanks, Aaron. So now I want to talk about the recent efforts by the National Labor Relations Board. Again, this is, a federal agency, so this applies to pretty much all employers, unless you truly are a small, lemonade stand in the summertime, in terms of their efforts to really try to regulate the terms and conditions of any separation or severance agreement. And again, normally we think of the National Labor Relations Board as being involved where the employer has a union that's representing their employees. That would be a mistake to assume that that's the limited jurisdiction of the NLRB. All employees have the same Section 7 rights to collectively bargain with their employer over the terms and conditions of employees. So just because your employees are not unionized does not mean that you're outside the scope of the National Labor Relations Act, or the National Labor Relations Board cannot come a knocking on your door. And this is beyond the scope of today's program, but another area where they are very active with going after non-union employers is aggressively attacking employee handbooks or employee policies. Again, that's a program for a different day. And I believe, John Gilbert in the past has covered similar programs along those lines for higher level. But here I'm going to talk about their new efforts to go after severance agreements. So the only scope of employees who are beyond the jurisdiction of the National Labor Relations Board are supervisors, managers, and above. So anybody who's an hourly employee and non-supervisory staff, they all have the Section 7 rights to engage in what's euphemistically referred to as protected concerted activity, and that is a legal term of art. But if 2 or more employees are complaining to you about the working conditions or your policies or your practices, they're protected under the National Labor Relations Board. And again, in the early days of social media, this was a real challenge where employees were sharing on Facebook or otherwise complaints about employer practices. That was all considered protected concerted activity. So anything that's deals with mutual employee interest is considered protected concerted activity. And the National Labor Relations Board is very aggressive in going after any employer tactics that they believe unfairly chills employees from talking about their terms and conditions. Classic example is having a policy that says you can't talk about what your bonus was or your wage increase was or your salary is. Those are all patently unlawful policies, and the NLRB will come in, sweeping if you have a policy or a practice of terminating employees who share wage information with themselves or with union, business agents. So now the board is now expanding this to, confidentiality or severance agreements because of, in their view, 2 different prongs here. Many severance agreements or separation agreements that you enter into employee at the time of departure for whatever reason, almost always have terms that impose confidentiality. So the labor board is going to look at confidentiality as to what subjects. They also may have terms that says you can't, disparage, the now former employer, and if you do, we'll come after you for a breach of contract. And what's disparaging in what context, again, can get into areas of protected concerted activity. So an employee is bad-mouthing the employer to a union business agent who wants to organize the employees. That would not be unlawful disparagement in the eyes of the National Labor Relations Board. So I'm not a big fan in general about overly broad confidentiality and non-disparagement provisions, particularly the latter, because what's disparaging almost begs future argument. But a lot of employers, again, want to have those protections. So now we have to be mindful of the new risks that may have in terms of overly broad confidentiality obligations or overly restrictive disparagement obligations, because the National Labor Relations Board is now willing to, step in and view those as unlawful. So I'm going to talk about, at least what the General Counsel has indicated is going to be her area of focus going forward. So first of all, the agreement cannot release any claims under the National Labor Relations Act in the first place. That's not a new requirement, but a lot of employers, may sometimes, rather than go to their lawyer and have the agreement prepared, they'll go off the web and download a copy, and if that copy includes a release of the National Labor Relations Act, the labor board is going to say that's an unlawful agreement. And likewise, if the agreement says person can't file a charge with the EEOC is going to have a problem with that agreement. As far as what you can keep confidential, you certainly, if want to protect trade secrets or proprietary information of the employer, those are so permissible subject. You can also keep confidential how much the severance was or the terms of the severance agreement. But you can't keep confidential as the circumstances underlying the employment relationship. This is partially a blowback from the the Me Too movement, with overly broad confidentiality obligations imposed in NDAs. And so if you're telling the employee they can't discuss their employment experience with you in the future, then the EOC is going to have a problem with that overbroad confidentiality, as well as the National Labor Relations Board. As disparagement, they basically said you can only prohibit an unlawful defamatory statement. And that really is a high bar about what is defamatory, because for the most part, statements of opinion, unless truly reckless, can't be defamatory. And so someone may post on, Glassdoor, they're a terrible place to work. That's not, per se going to be a defamatory statement. So again, that's in part why I'm not a big fan of non-disparagement obligations to begin with, because it almost, guarantees there's going to be a future fight. But they can be, now a challenge in front of the labor board. The other thing that the board is taking position is merely offering the agreement, even if they don't sign it, that's a violation. And then more remarkably, the general counsel is taking the view that these standards apply to all of your prior agreements that you've entered into before the labor board announced this new standard. So in theory, they expect you to contact everyone you've entered into severance agreements in the past that has these overbroad confidentiality or non-disparagement provisions and modify their agreements. Now, we're not per se advocating that you do that, but at least from the labor board perspective, there is a risk that they could, if they again audit you, might force you to do that with any past agreements. So it's one thing to comply with this prospectively. It's another consideration. You have to go back and modify all these agreements in the last 5 years or more. So again, this was a decision reached earlier this year, and the general counsel memo is just that. It's a memo. Certainly, there's going to be court challenges to whether or not that's a proper interpretation by the labor board. So stay tuned for further developments there. The National Labor Relations Board is comprised of 5 members, and 3 of the 5 are always consistent with the party who is the current president. So right now, with President Biden in the White House, there's 3 Democrats on the labor board and 2 Republicans. If the 2024 elections go the Republican way, then the next president will be able to change that voting ratio to 3 Republicans and 2 Democrats. And where there's a strict party line vote, 3 wins. Going forward with any separation agreements or severance agreements that you enter into with new employee, or not soon to be new, former employees, the safest course is to comply with the GC's memo. And if you're completely risk adverse, this is something you may want to consider. Again, there are some other ways to still maintain maybe a broader confidentiality or broader non-disparagement if you include language that explicitly reflects that the employees have the right to still engage in protected concerted activity or go to the National Labor Relations Board. I'm not a big fan of telling them how they can enforce their rights with the NLRB in the context of an agreement. So again, if you're doing severance agreements, we may want to consider the scope of less rather than more confidentiality, or even including non-disparagement in the first instance. And certainly, whether it's Jackson Lewis or whoever you have an employment counsel, now's the time to, if you're doing your own separation agreement yourself, now's the time to have them updated with counsel or make sure they would pass scrutiny if someone brought the agreement to the NLRB. Questions before I move to the Pump Act and the Pregnancy Act?
I don't see any coming through right now. I'll keep an eye out.
Okay. So the Pump Act Again, as we all know, we're in the news right now with the deficit default discussions, and so whenever we have fiscal issues like that, there are always all kinds, at the end of the day, grandiose horse trading that occurs. Last December, believe it or not, was when Congress finally passed the budget for the current fiscal year on December 29. So the Consolidated Budget Act had all kinds of goodies loaded into it to achieve passage, one of which include the Providing Urgent Maternal Protection for Nursing Mothers Act, otherwise known as the PUMP Act, which again expands the obligation to provide break time and adequate space for employees that need time off to express breast milk while they're at work. It makes clear that if they are working while they are pumping, take your laptop with you or take your tablet with you and respond to emails, then the pump time is compensable, even if it lasts more than 20 minutes. So we need to be careful there. It also is going to expand who's entitled to time off to express milk, to include all employees, exempt salaried employees, and not just hourly employees. And it also expanded some legal protections for accommodation requests. So most people are aware already that since 2010, as part of the Affordable Care Act, the Fair Labor Standards Act, ironically, was amended to allow non-exempt employees sufficient time off to, during their workday to express, to pump and have a private space. And ordinarily break time, if it's 20 minutes or less, is paid time, compensable time. If it goes beyond 20 minutes, it may not be compensable, although for you Illinois employers, it's still going to be compensable there because Illinois law provides that the break time for expressing milk is paid time. So the exempt employees are going to be, if they're taking time off to express milk, they still get their full salary regardless of how much time they take. The Pump Act does have some exceptions if you are truly a small employer with less than 50 employees. I will caution you, though, that you have to establish that complying would be an undue burden and expense, and I would suspect that the DOL will be very leery of recognizing, this is an undue burden or expense, but there is that exception there. The Department of Labor just last week issued a field assistance bulletin. So if you go to the DOL website, you can download this, document. It's about 10 pages long. And this is essentially the marching orders to the DOL staff about, how they are to enforce a complaint if it comes in. So it basically is telegraphing to us what they're going to be looking for. And so, first of all, they recognize that the amount of time it takes for someone to express milk is going to vary by the individual and a number of factors. So we can't put a hard clock on everybody. The type of space that we make available, the location, that can add to the time of a necessary break. The employee can agree with you to, here's my set schedule when I'm going to do it. But we cannot mandate the employee to a set schedule. And if they do agree to a set schedule, certainly they can change it if they feel they need to. And the DOL also reminds you that if you have employees that teleworking remotely at home, they too have the right to be, off work to express milk. Some employers have their remote employees have to be, viewed by camera phone while they're on duty. During that time, you have to, allow them to turn the camera off. Now, the good news is you don't have to make sure that they have adequate space to do this in private at their home or their remote work site, but you still have to allow the remote employee time off during the day in order to express milk. The guidance also provides some more details about, what is an adequate space. First of all, it's going to be one that's shielded from view or intrusion by either their coworkers or the members of the public. It has to be one that's available whenever the employee needs it. So if you have 3 or 4 employees that are all expressing milk at the same time, you may need more than one space available depending on, on their work schedules. And under no set of circumstances, doesn't matter how pristine it is, how often it's clean, the space available to express milk cannot be the bathroom. So again, depending on a small employer, that sometimes can be a challenge. But the bathroom can never be the default choice. It can be any area that's temporarily created. So literally could be the corner of the office with cubicle walls that block the view. So long as you comply with the requirements above, it can be acceptable. It could be your office. You vacate it when the employee comes in and uses their equipment and comes back, and then you go back to your office if you have a separate office that otherwise is being used by someone else. The DOL recognizes that preferably the space should have both electricity and a sink, because both of those will allow for, in theory, shorter break times. And finally, you have to make sure the employee has the ability to store their milk either with an insulated food container, a personal cooler, or refrigerator on site. So again, since the broader folks are now going to be entitled to time off to express milk, you just need to make sure that, one, you've got your staff trained to be aware of the new requirements, and also, more importantly, what your space is going to be when someone needs to express milk and set up their equipment. So again, this is more of a challenge for smaller employers with smaller offices, and that is not going to be ordinarily an undue burden defense. So may have to be creative, and I think we've seen some of these in airports. There's now a business where people are actually having pods delivered to businesses that are designed solely for expressing milk. So those may be solutions as well. Questions before I turn to the Pregnancy Fairness Accommodation Act?
No, there are no questions so far.
Okay, so just as a little history lesson here, originally, the U.S. Supreme Court back in the mid-70s concluded that pregnancy-related conditions, even though it only affects, women, was not covered by Title VII's prohibition of sex discrimination. So originally, Congress then overruled the Supreme Court and passed the Pregnancy Discrimination Act in 1978 that went on to define sex discrimination includes discrimination based upon employees' pregnancy, childbirth, or related medical conditions. And so this, generally created a duty not to discriminate against employees because of pregnancy, but it didn't require, it basically says you had to treat pregnancy like you treat all other medical conditions, no better, no worse. There was no duty to accommodate the pregnant employee as a matter of federal law. Under only state law, that's been the place for the last 10 years. But again, starting this year, starting in June, as part of the same Budget Consolidation Act last December, Congress also included the Pregnant Worker Fairness Act, which essentially is going to treat pregnancy like a disability from the ADA perspective in terms of reasonable accommodations and all those procedures. Historically, pregnancy in and of itself was not an ADA because it's not a permanent condition. It's only going to last at most 9 months, maybe a couple days thereafter, or sometimes even less than 9 months. But unless there was some other medical complications associated with the pregnancy itself was not an ADA disability that required a reasonable accommodation. This new law essentially creates that duty for pregnant employees, even though it's not under the ADA. It's going to be part of this new statute. So now we are going to have to accommodate employees who have pregnancy-related conditions such as morning sickness or needing time off because of their prenatal visits. or any other accommodations, that we have to look at in terms of workplace alterations because of the employee's, pregnancy. And so this is going to be covered, governed by those employers. Again, in Missouri, you have to have 15 or more employees to be required to accommodate your pregnant employee. In Illinois, it's 1 or more employees under the state law, but at least under the federal law, you still have to have 15 or more employees to have the accommodation obligation. And so if you have an employee who's having pregnancy-related problems that are affecting his or their ability to do their job, you're going to have the same sort of good faith interactive dialogue with them on possible accommodations. And what you can't do is, if there's an accommodation you could provide that would allow them to still keep working, you can't force them to go on FMLA leave. If there are no other accommodations that could be provided, then FMLA would be an option if you're a covered employer. But if there is an accommodation that could be provided that would allow the person to continue working, notwithstanding the pregnancy condition, then we're going to have a dialogue with that employee, and then we get to choose which one's effective. So the employee can't mandate one accommodation or the other, but we at least have to provide one if there is an available accommodation there. So it's essentially going to require you to expand your ADA process already, dealing with pregnancy and other problems the pregnant employee is having. Many, and if not most, employers were already doing that, but now, as a matter of federal law, it's legally required. This act also provides significant remedies available for the employee if the employer fails to reasonably accommodate the pregnant employee. And so we're now, as a result, going to look at, do we need to update our handbook policies, either in terms of, our current accommodation policy. Certainly need to have our managers aware that, if they have employees who are struggling at work because of morning sickness or other problems associated with their pregnancy, we may have to have a proactive dialogue with them. We don't have to wait for them to come forward. We have to proactively address the situation. And again, we just really need to, again, expand our ADA process to now include the pregnant employee. This is finally, a number of other states, including Illinois, that have separate pregnancy accommodation laws that would need to be viewed. Missouri, is not one of those states. So under Missouri, it would just be if you're a covered employer with 15 or more employees under either, federal law or state law. So the Missouri Human Rights Act. But in Illinois, again, we're covered by both federal and the Illinois Pregnancy Discrimination Act. So questions on the Pregnancy Fairness Act or anything else I've talked about in the last 57 minutes and counting?
Yes, we do have one that came in from Amber. So she had asked if front-loading time for a part-time employee, would you do 40 hours or would it be based on their normal hours of the week? For example, 28.
If the schedule contemplates they would work 28 hours a week, then you would essentially, front load them 28 hours. Whatever the anticipated schedule is, at the time, again, if that changes, then you'd have to, perhaps, add additional time. But if they're routinely working, expected to work 20 hours a week, then that's the amount of hours you would front load for that person. Or 20 hours or 10 or whatever is contemplated as their average weekly schedule.
All right, we can give everyone about another minute or so, but I do not see any other questions. If you have any questions coming in, guys, feel free to drop those in the message box or the chat box, and we can get those answered here for you before we wrap up.
And again, I'm going to be doing another program later this fall for higher levels. So please let Erin know if there's any topics you would like covered in the future, and we'll make it as effective for each of you as we can. Otherwise, thank you for your time, and I hope this has been both informative and helpful for you over the last hour.
Yeah, thank you so much, Tom, and thank you everyone for starting your morning with us. Before we wrap up, I did want to let you all know we do have another topic coming up at the end of June that will be covering all about an ocean inspections. So if you're interested in that topic, again, feel free to email me directly at hello@higherlevel.com. That's the quickest way to reach me. And then, like Tom said, he will be back on deck with us. I believe it is in November. So if you have any pressing topics that you want to hear more about, you can email me those as well, and we can add that to the docket. All right, thank you all, and have a good rest of your day.
Take care, everybody.